Mrs. Smith.
Lady, my lords, I'm going to deal with 3 issues this afternoon, subject to anything else that arises during the course of my submission. The first is independent choice. The second is my Lord Sumption's point as to the prior aspect of the but-for test. And the third are some additional reasons as to why the Commercially test applies in this particular case. So can I start off with the question of independent choice? And can I just postulate this example, if I may? Consider a case in which the borrower pays off the first loan in circumstances where there is no contractual obligation in the second loan contract that he should do so. Instead, he chooses to do so. Now, that would be on all fours, in our respectful submission, with Commercially, because it's just as independent a choice on the part of the borrower as it was by SR to use letter of credit 2 to pay off letter of credit 1 in Commercially. But if that's right, you then need to ask, well, what difference does the existence of a term make? And if the only difference it could make is that it negatives the element of independence, well, we say that's not enough. That can't be a sufficient reason because, in fact, we know from the cases that independence is not the true principle. And we see that most starkly in the case of BTC and Gurley in the House of Lords. That was the case about taxation. And I just wonder if I can take you to BTC and Gurley.
Can I just ask you this? On the hypothesis that you're now putting forward, would the facts not be broadly similar to those which in Commercially it was conceded would give rise to a deduction? Because per paragraph 63, the SR was itself the beneficiary of the letter of credit.
Yes, so it was conceded that it would be a collateral event and therefore give rise to a deduction.
I understand.
So, my ladies, if we could look at BTC and Gurley, please, which is in tab 16 of volume 2 of the authorities, at electronic bundle page 1193. And you will remember that this is the well-known case involving payments of tax, the personal injury claim, and the issue as to whether damages for loss of earnings should be assessed having regard to tax that would have been paid on those earnings absent the injury. And the House of Lords held by a majority that the tax position had to be taken into account. It was not raised inter alias acta. But in doing that, we can see, in fact, the analysis shows that the independence test doesn't explain when circumstances arise which may be raised inter alias acta or not. So if we could go, first of all, please, to page 201. Actually, starting at page 200 within the authority. This is within the speech of Earl Jowett, who is dealing with the previous case of Blackwood and Andre, in which Lord Keith gave a speech. I'm so sorry.
1208.
I'm very grateful to my lord. Starting at the bottom of page 200, Earl Jowett refers to Lord Keith in Blackwood and Andre, decided that no deduction should be made from the amount awarded in respect of loss of earnings on the ground that these earnings would have been liable to income tax. Lord Keith expressed his disagreement with the reasoning of Lord Sawn in Medade's case. He gave his reasons for disagreeing in the following terms. The basis upon which the argument proceeds is that a pursuer is entitled to restitution as far as possible of the loss which he has sustained as the result of the injury for which the defender is liable. The suggestion is that what he has lost is only the net sum which he would receive after the deduction of income tax. That argument has a certain speciousness, particularly if tax is regarded as tax deducted at the source. must be remembered that not all tax is deducted at the source, and that the same argument would apply to a person who receives certain income for which he had himself to account to the revenue. But apart altogether from that, the consideration appears to me to be quite an illegitimate one. And then he said this: it would apply on the same grounds where a person had come under obligation to pay a proportion of his income away to somebody else. The fact that he would then be left with a net sum does not appear to me to be any reason for basing the assessment of damages upon the net sum which he would receive or retain, and not upon the gross sum which should be paid to him and from which he would make the conventional deduction to which he had become bound. So Lord Keith is there not relying on the question of independence in the context of res inter alias acta, because there he is clearly saying that where individuals who have a pre-existing obligation to pay money, that may itself be res inter alias acta. Now, it is fair to say that that particular case was overruled by BTC and Gurley in the context of the decision on tax, but not in respect of those observations. And in my respectful submission, that is plainly authority for the proposition that independent choice is not the right test in looking and assessing whether something is truly to be regarded as a collateral event. Lord Reid, at page 213, made, I think, a similar point, starting at the bottom of page 212, right at the bottom. It has sometimes been said that tax liability should not be taken into account because it is res inter alias. That appears to me to be a wrong approach. That was because the Latin tag was not an appropriate approach to take, because a tax payment very clearly was in relation to a third party. Let me take the case of a professional man who is injured so that he can no longer earn an income. Before his accident, he earned fees and he paid rent and rates for his office, the salaries of clerks, the expenses of running a car, and other outgoings, and he would have continued to do so if he had not been injured. Apart from one matter to which I shall refer later, I cannot see why these expenses are any less res inter alias than his payments of income tax in respect of his net earnings. Now, the reason that the majority of the House of Lords found that income tax was not, in fact, collateral was because taxation is not something purely personal to the plaintiff. And if we could go over the page to 214, one can see that still in the speech of Lord Reid, and this is where he explains the one matter to which I shall refer later, which in his view excluded taxation from the general run of things. And he says this in the second paragraph: I return to the question whether the fact that the plaintiff now has to pay less tax than he would have done is a factor too remote to be taken into consideration. Taxation is not something purely personal to the plaintiff. The obligation arises from acts of Parliament and applies to all. And then he went on to set out his comments near the bottom of that page as to the formulation, the difficulty of formulating the principle. And he said, I don't think it is possible to formulate any principle by which it can be determined what is and what is not too remote. Main on damages refers to matter completely collateral, and for a general description of what is too remote, I cannot find better words, but I do not think that every case can be solved merely by applying those words to it. Taking this description, however, and applying it to the present case, I do not think that the plaintiff's personal position is completely collateral. It is not something brought in as a separate factor, but only something which helps to quantify an obligation which is imposed by an Act of Parliament as a consequence of earning income. And I cannot regard that application as in itself collateral, certainly not completely collateral. And that passage is specifically referred to by Mr. Justice Toulson in Commercially, in the passage that I referred you to earlier. So he was relying specifically on that particular remark. Now, the fact that independent choice does not form the test is very clear in my respectful submission from that case, as is the fact that the question turns on whether the benefit has some inherent relationship with transactions of the kind that the claimant entered into. So the reason that the tax position had to be taken into account in that case in contradistinction to, say, an obligation to pay the same percentage of one's earnings to a third party under the terms of a contract, was because it was almost universal in its application. See Earl Jowett, the passage I've just referred to. And also because it was not something purely personal to the plaintiff. That's Lord Reid on that page 214. So the incidence of tax is not collateral because it's something one expects to find generally, whereas a private contractual arrangement involving the individual is an idiosyncratic feature of the individual claimant. And my Lord, you'll remember that in response to a question my Lord Sumption put to me earlier today, I responded that this is an idiosyncrasy of the particular contract as between the claimant and the borrower here. And in my respectful submission, BTC and Gurley supports that analysis, that if one has a situation where one would ordinarily expect something to occur as a feature of a particular event, then that may not be collateral. But if one has a situation which is particular to the contract itself, that is an independent feature which may be properly regarded as a collateral event. And of course here, the purpose for which a loan is to be used is a purpose which is unique to the individual lender. It's not usually or generally the case that a loan made in reliance on a negligent valuation is used to pay off a pre-existing debt owed to the lender. That depends on the peculiarities of the individual transaction. And we say there's nothing in the nature of a loan itself which requires it to be used for one purpose or another. It is the fact that the benefit arises out of the peculiar features of the individual transaction that makes it collateral. But independent choice, my lady, my lords, is not, in my respectful submission, the test. It is sufficient, but it is not necessary. And Mr. Justice Toulson, as he then was, plainly in our respectful submission, appreciated that in the Commerciany case, where he directly cited that passage from Lord Reid in BTC and Gurley.
Say, Mr. Smith, I'm struggling with the notion that one can say that something is collateral because it's private and an idiosyncratic feature of the very transaction in question, merely because something else is not collateral because it's a universal obligation like an obligation to pay tax. I mean, just standing back for a moment, the fact it's an idiosyncratic feature of the very transaction in issue might be a good reason for thinking that it wasn't collateral.
Well, my lord, it's an idiosyncratic feature in the sense that it is not what one would necessarily expect from the transaction. So insofar as a valuer and lender are concerned, the valuer doesn't have any expectations as to what is going to be done with the money. There's no ordinary consequence of the loan in the sense of using it necessarily to repay a pre-existing loan. And that is why, in my respectful submission, an individual consequence is something that is collateral, that is independent. It's not caused by that initial transaction.
Are you not confusing causation and remoteness?
Well, my lord, in my respectful submission, I'm not. This is very much a question of remoteness in the context of collateral events, as that word is used in BTC and Gurley, which is a causal issue. It is a question of causation, not of foreseeability.
But remoteness is normally applied to something which is in fact caused, but which the law regards, for good reason, as too far removed from the contemplation of the wrong.
Yes, that's the foreseeability.
To affix him with liability.
Yes.
Here you're using a similar principle, apparently, to suggest that something which is not caused by the relevant transaction should nonetheless be treated as caused by it, since the factual basis for a purely pragmatic conclusion that it wasn't caused isn't something which the wrongdoer is likely to have expected.
Well, my lord, that was the reasoning of the House of Lords in BTC and Gurley in supporting the decision they arrived at in relation to tax. And that is a question of causation And it's not concerned with foreseeability issues. I'm not making a submission about foreseeability. And insofar as they use the context of remoteness, they don't use it in the context of foreseeability, but rather in the context of an issue around collateral benefit, whether something is truly to be regarded as independent, remote, or not. And that's the way that's being used by the House of Lords in BTC and Gurley. And my lords, my lady, Gurley, of course, is not a remoteness case. It's not about foreseeability. It's purely about the application of the doctrine of res inter aelius acta. In fact, although their lordship said, well, res inter aelius acta doesn't help, the reason they said it doesn't help is because the Latin tag is misleading, as my Lord Sumption made clear in the Swinson case in paragraph 11. It's not about remoteness. It's actually about collateral benefits. So, my lords, in light of those submissions, we say in this case that the repayment involved the repayment of an existing loan which had nothing whatever to do with the negligent valuation, and that repayment doesn't cease to be collateral merely because the contract under which the second loan is made itself specifies the purpose of the loan. The lender's complaint, so far as the valuer is concerned, is still that it was induced to make a loan which it would not otherwise have made, and that this loan has not been repaid, either by the borrower or by realising the security. And what the borrower did with the money doesn't form part of the lender's complaint, and any benefit that's derived from it therefore remains collateral in our respectful submission. And you might think that the independent choice test would lead to anomalous consequences. On that analysis, it follows that the use by a borrower of the second loan to pay off the first, where the contract doesn't impose any requirement as to the purpose, would be collateral, as I've said. And in such a case, the borrower's decision to use the proceeds of the second loan to pay off the first would be just as independent in our submission as SR's decision, the bank's decision, to use the proceeds of the discounted letters of claim to pay off BCL's debts in Commercially. Now, what that means is that the result in lender-valuer cases would vary according to the terms of the contract between the lender and the borrower. The outcome would depend on whether the contract with the borrower contained a term requiring repayment of the first loan or not. And in our respectful submission, just positing it in that way clearly indicates that that is not the correct result. That would be a very surprising, and we say anomalous outcome, because, well, not least because the terms of the lender-borrower contract are immaterial to the valuer's task. Just one further example on this point. If, for example, the terms of the loan require the borrower to use the money to make a particular investment, for example, to buy the lender's shares, not a very likely example, but nonetheless, and that gives rise to a further benefit to the lender, for example, the share price rises, it could not be suggested that the lender would have to give credit for this in a claim against the valuer if the loan remains unpaid. There's no difference in our submission between that example and our case. They're both examples of a benefit which the claimant would not have received but for the wrong complained of. So independence is not the test. The test is the nature of the payment itself, the character, the intrinsic character of the payment. And here, the intrinsic character of the payment is collateral to the transaction entered into between the lender and the valuer. My lady, my lords, can I then turn, please, to the question of the prior point being the basic comparison, which my Lord Sumption identified as a key issue this morning. And the answer to it, I think, is this, if I may. First of all, if one has any tort or any breach of contract, then many events may happen after that breach. And those events may give rise to a gain or to a loss to the claimant. And if that event giving rise to a gain or a loss would not have happened but for the breach, there is a but-for connection between the breach and that event. For example, the insurance payment case. They're connected in the but-for sense in that an insurance payment wouldn't have been made but for the injury to a particular claimant. But nobody can properly suggest that the but-for connection is itself enough in relation to either an event which causes a loss or an event which causes a gain. And the reason for that is causal. It's not a question of remoteness in the context of foreseeability. It's a causal reason. So, for example, if in Swinson on the facts, Mr. Hunt had paid Swinson gratuitously, which was accepted by everyone in the Supreme Court as being an example of a collateral situation, that does not form part of the basic comparison. And the reason it doesn't form part of the basic comparison is it is not caused by the breach. So one has to, in our submission, analyse what it means to say we would have lost the first loan in any event. It means that the second loan enabled us, in the words of Lord Justice Moore-Bick in this case, enabled us to avoid a loss because the first loan was discharged and would otherwise not have been. Something that merely takes us off the hook, takes a lender off the hook of loss that he might otherwise have been exposed to, it is not caused, we say, by the breach. And if it's not caused by the breach, then it's not relevant to the assessment of damages. And in this case, the repayment of the first loan by the second merely took the lender off the hook in relation to a potential exposure. So, in direct answer to my Lord Sumption's point, factual causation, the but-for test, as identified in Nye Credit by Lord Nichols, is not, with respect, a prior point, because you can't identify factual loss without applying the question of whether there are benefits or gains, in this case collateral benefit, without applying mitigation, without applying novus actus. Effectively, what you're doing when you're looking at an analysis of loss in a case such as this is drawing up a balance sheet. It's what you're doing in any tortious claim, in any contract claim. And that balance sheet consists of any event which was caused by the breach, some good to the claimant, some bad, some providing for a gain, some providing for a loss. And the net position is the loss. And on the breach side of the coin, you have to eliminate factors such as novus actus, collateral events. So I'm not going to take you back to it, but thinking about the basic comparison in Nye Credit, all that Lord Nichols was doing in Nye Credit was giving a particular illustration of that process in a simple no-transaction case where the counterfactual is that the lender would not have entered into the loan, and the factual is that he did in fact enter into the loan. Lord Nichols wasn't concerned with the gains or losses on either side of that equation because he was looking at when the cause of action arose for the purposes of interest. So for those reasons, we say that the but-for test is not in itself determinative. The concession that I made below, that the basic test itself, if you simply applied it stripped of everything, would create problems for us, it is accurate. But you can't apply it stripped of everything. You must apply it in the context that I've just identified by reference to other rules of damages, which are causal rules. not rules that are concerned with remoteness. My Lords, that deals with the prior points that my Lord Sumption raised, unless there's anything else I can help with on that. So if I can then simply turn to why the Commercially principle is applicable here. I should make the point that my learned junior reminds me of it, that if we are right on the point that I've just made, then that is determinative of the case because there is no issue around the prior point. Coming then to why the Commercially principle is applicable here, and the main point I wanted to address in relation to this was I think it was the fifth point that my learned friend Mr. Hickey made this morning about Commercially being a fraud case. My lady, my lords, the fact that Commercially is a fraud case is, in my respectful submission, nothing to the point. It does not mean, insofar as he was suggesting by that Mr. Justice Toulson was identifying a particular rule that was only applicable in fraud cases, that would not be the correct analysis. Not least because Mr. Justice Toulson very clearly referred in his judgment to paragraph 165 to the Gurley case, which of course is a case about the rule of causation, not remoteness, and is not, on any view, a fraud case. But the argument that Commercially can be distinguished because it is a deceit case is also wrong, because any distinction between deceit and negligence in the context of res inter aelius acta would be unworkable. And it would be unworkable because if there is a difference between deceit and negligence, the difference must favour the claimant who sues in deceit. It couldn't possibly favour the fraudster. So in relation to remoteness of damage, foreseeability, the difference favours the claimant who sues in deceit because there's no foreseeability limit, for example. In relation to the res inter aelius acta principle, the rule can't be that the doctrine simply doesn't apply in deceit claims. We've seen in any event that in Commercially it does. But if that were the rule, that would mean that the claimant who sues in deceit is worse off, not better off, because he would have to give credit for all the benefits, even those which would be res inter in a negligence claim. So a special rule, if there were to be one, could only work if it went the other way. That is, if it said that all the benefits received by a claimant who sues in fraud are res inter aelius acta. That would, for obvious reasons, produce absurd results. So if the claimant is induced by a fraud to sell goods to the defendant, the claimant would not have to give any credit, even for the price paid by the defendant. Any such distinction between deceit and negligence in the context of the res inter aelius acta principle would therefore obviously be wrong in principle and unworkable in practice. Mr. Justice Toulson in Commercially does not decide that case on the basis of a special rule for fraud. He simply asks whether a particular benefit is res inter aelius acta or not on the basis of the usual test. And he doesn't say that that rule doesn't apply or that every benefit is res inter because the claimant is suing in deceit rather than in negligence. The other point to make is, of course, that the rule that the claimant must mitigate his loss applies equally to deceit and negligence, and one has that in the Smith-New Court decision and the Standard Chartered Bank and Pakistani National Shipping Company decision, neither of which I need to take you to, but it's very, very clear that the rule in relation to mitigation of loss applies in the same way to claims in fraud, in deceit, as it does to claims in negligence. There's no reason in principle or policy why it should differ in that situation. And there's no reason why the res inter aelius acta principle should be different either or should apply differently in either case. My learned friend has not cited any authority which suggests that the test of collaterality varies according to whether the claimant sues in deceit or in negligence. So that addresses the point on fraud. There are just a couple of additional points that I wanted to make in relation to the application of the Commercially principle to the facts of this case. The second concerns the fact that the principle is particularly apt in claims against valuers. It's a point that we've made in our written case, and it's a point that I made earlier this morning by reference not least to Lord Hoffman's analysis in the Samco case that a valuer is not privy to the commercial reasons for or the purpose of the loan. What I am not doing in making that point is making any comment about remoteness in the context of foreseeability. I'm not saying that this involves the creation of some kind of warranty, that this is a warranty type case, as Lord Justice McComb identified in his dissenting judgment in the Court of Appeal. I'm saying what needs to be done is to ask whether this particular event is peculiar to the plaintiff and the defendant. And in our respectful submission, the payment of the second loan discharging the first is a peculiar event to the plaintiff and the borrower, which is not related to the transaction as between the plaintiff and the valuer. And the scope of duty issues serve to illustrate that factor. But what I'm not trying to do is bring into play the second aspect of the NICredit reasoning in supporting my arguments in relation to the collateral nature of the payment. My third point, and again it's in the written case, is that our approach is entirely consistent with Swinson and preferred mortgages. And I think I made that point this morning, and I'm not sure that there's anything further that I can say about that. And the fourth point is that there is no unfairness to the valuer in the operation of this rule, the Res Inter Aelius Acta rule. We've again dealt with this in our written case, but it's worth pointing out, of course, that there is a symmetry in the operation of the rule. So a collateral event is left out of account whether it produces a gain or a loss. And that is important. There's no unfairness there. The operation of the Res Inter Aelius Acta principle would never increase the valuer's liability beyond what it would normally be, or deprive the valuer of the Samco cap. The valuer will simply be liable for the consequences of the lender making the very loan in respect of which the negligent advice was in fact given. So in my submission, there's no anomaly there in applying the Res Inter Aelius Acta principle in a case of this type. My lady, my lords, could you bear with me just a moment? Unless there's anything further that I can help you with, those are my submissions.
It appears not, Miss Smith. No. I'm not entirely sure which of your juniors is entitled to be called upon, but I suspect Professor Peel.
I'm most fortunate to have two of them.
You have two, and one's call is 2014 and the other is 2015. And they both look far more senior than that. So, thank you.
Thank you, my lady.
My lady, my lords, very briefly in reply, if I may. The first point is to pick up the point about the transaction, the second loan transaction, and the fact that there was an express term, not an implied term, an express term that it should be used to pay off the first. And in my submission, our submission, that makes it integral to the whole transaction and therefore can't be regarded as collateral. It does violence to the English language to suggest that it is collateral. Could I give you the reference for that? Electronic reference to the facility letter of December 2011, which is MS 202, or in the hard copy version behind tab 10 at page 103 or 639, take your pick, where the facility letter dated the 16th of December 2011 issued to the borrower says under section 9 purpose, the purpose of the facility is refinance and development to be confirmed by your solicitors. The short point, therefore, is that the borrower was given no choice. This is not a situation where the lender said, having lent you £2.5 million already, I'm going to lend you an additional 3 million, and you can do with it what you will. It never intended to lend 5.5 million. It only ever intended to lend 3 million, a total of 3 million, of which 2.5 had previously been advanced.
Would it make any sense to lend 5.5 million on the valuation that your client had provided?
It would have made much less sense. So no, it could never have been within their intention to do that. So that's the first point. There was an obligation on the borrower to repay the first loan. And therefore, as I said, it does violence to call it anything other than intrinsic and causally related to the second loan to the first loan. And therefore, we say the whole point about the collateral benefit collapses on that point. My learned friend spent some time looking at commercially and the fact that it doesn't really matter that there's an independent choice. Well, for the reason I've just explained, it does matter a great deal. But one of the reasons why it matters a great deal is the independent choice of a party to do with the money, whatever it is a pointer. It may be no more than a pointer to whether or not something is extrinsic or to be treated as intrinsic. And therefore, that is a very significant point of departure or distinction between the Commercially case and the facts that we have here. My learned friend referred to the fact that in Commercially there was reference to the principles set out in Gurley at paragraph 166 of Mr. Justice Toulson's decision in that case. And it's true to say that he does refer to Gurley, but one has to take into account what Commercially is dealing with and what Gurley is dealing with and what it is not dealing with. The Commercially case mentions the words but for, but in an entirely different context. And I'll come back onto that in a moment. It's not asking the basic first comparison test. There are two questions. You have to get over the first, otherwise the collateral benefit analysis is a secondary stage you don't need to get to. And Commercially is not asking that first question. And the reason it's not asking that first question is because everybody knows that the loss has been established. The fraudsters have taken $94 million of the bank's money. There's no question that the first test has already been established. The point of difference between Commercially and this case is the very question that begs the question, has there been a loss, and if so, what is the extent of that loss? And we say that there has been no loss because that loss was already suffered by reason of the previous indebtedness. Let me look at what Gurley, I'm not going to look at precisely what Gurley says, but let's go to the classic case, or perhaps the leading case, Partchase Swinson, on collateral benefits, which is the House of Lords decision in Parry and Cleaver, which is at page MS 1333, or for those who are old school, behind tab 21 in the authorities volume. And I'm sorry, I don't have the precise page, but let me read it. The famous speech of Lord Reid in that case, also quoted by Mr. Howard in the Swinson appeal, and he identified, it's at page MS 1345. He identified.
Can you give me the page of the report, please?
Sorry, yes, page 13.
Thank you.
And in the very second paragraph, he identifies essentially that there are two questions. So we have a symmetry there between what we're saying and what Lord Reid was saying there. The first, what did the plaintiff lose as a result of the accident? What are the sums he would have received but for the accident? You can see the but-for test is alive and well in Parry and Cleaver, but which by reason of the accident he can no longer get. And then he identifies the second question. Secondly, what are the sums which he did in fact receive as a result of the accident, but which he would not have received if there had been no accident? Then he goes on to identify the case of Gurley in the next paragraph, and the universal rule he refers to, that the plaintiff cannot recover more than he has lost. And then the passage which I commend to the court at letter F. But Gawley's case had nothing whatever to do with the second question. It did not arise. So Gawley is not a case about collateral benefits. And Commercially and the other cases are not questions that answer, they cannot answer, the first question, which is the question that my learned friend has to get over before even considering the collateral benefit. Her analysis just simply doesn't get that far along the road. Now, factual causation, as I said in my opening, is a necessary, but it may not be a sufficient answer. You have to get over the factual causation first, and they fail to do so. Of course, there are other rules that come into play if you've got over the factual causation question, but they don't do so. And what Commercially is dealing with is when you have got over that factual question, whether there are benefits that then need to be taken into account, depending upon the nature of them, whether they're extrinsic or intrinsic. And in that sense, that's why he uses the words but for in paragraph 167. So what we now need to do, if you may, to turn back to Commercially at page MS 926 or Authorities Volume 1, tab 2, page 46. And what my learned friend said to you a moment ago in closing was to say, well, these other rules are part of the causal case. They are and have to be treated as part of the but-for factual question, because how could you divorce them from it? We don't accept that. That doesn't stack up at all. What cases like Commercially are getting at is that those causal rules for the but-for test of factual causation don't help you with the secondary question. Because a but-for causation question, not the but-for test, but the but-for question of causation is things wouldn't have happened. If I didn't enter into the room, then I wouldn't have discovered X, Y, and Z. Well, true. I mean, one can always say that certain things wouldn't have happened but for something else. And so that is the context in which Mr. Justice Toulson, as he then was, said at paragraph 167, the question whether an alleged benefit should or should not be taken into account can't be determined by a mere application of the but-for test. There are a whole host of other very fact-sensitive matters that you then need to take into account to see whether or not a credit should be given or whether the benefit should be discounted, depending upon what it is. And so, for example, in the classic type of collateral benefit in insurance, insurance is not to be treated to reduce the amount due to the victim for two good reasons. One is that if he's taken insurance premiums, he's paid insurance premiums. And he's paid insurance premiums so that he can have that benefit, which is incidental to, not dependent upon the original breach. It's an entirely separate matter, a private matter between him and his insurance company. And allied to that, of course, there would be no double counting. Because, of course, once the insurance company has paid out the benefit, there will be a subrogated right anyway against whatever damages there may well be. Of course, that doesn't arise in a case like the present. When it's the same lender, there would be no question of subrogation. The lender has just suffered no loss if he's already indebted. He's already got a debt on his books. So these are very fact-sensitive points when you're looking at the second question about collateral benefits. And that is exactly what Mr. Justice Toulson is referring to when he says at the beginning of 168, on which much emphasis has been relied by my learned friend. It's necessary in each case to identify the relevant venture or transaction. That's not just simply about these letters of credit, as to which whether they were paid off or not is a matter of choice. It's the fact that in order to determine whether the benefit should be taken account of or not is a highly fact-sensitive thing. Now, the fact here, in our case, is that they are thoroughly intrinsic. Because, as I've said, the loan was made simply to repay the earlier loan. And to divorce the two, it has an air of unreality about it. My little friend, as she customarily does, with absolute candour and precision, identified right at the very outset of her case that the decision reached by the majority is not a reasoned decision which explains how it was they got to the position they got to. She blames herself. She should not. I don't.
Another example of recule pour mieux sauter.
Candour and gallantry combined.
Well, I'm doing my best to even things up. But the reality is they ducked the question of but-for. And in order to keep things back on an even keel, I would commend to this court that it's put back the straightforward application of the but-for test. That otherwise, madness lies in trying to conflate the second part of the second questions about collateral benefits with a very simple, straightforward foundation on which compensatory principle decisions have been made by these courts for hundreds of years. And so I would suggest that you allow my appeal kindly and reject the Court of Appeal's analysis, unless there's anything further.
I fear not. Well, thank you all very much indeed. As always, it's wonderful to get a common law point for us to chew over, and we shall go and chew it over and let you know the result, of course. But thank you all very much indeed for your submissions. The court is now adjourned.